Good afternoon. I think it's afternoon. Is this on? Yes? Can you all hear me? Great. Well, thank you very much for coming, and thank you for thinking about the Mental Capacity Act as something that might be empowering. I assume that you think that because that's why you're here. I think it should be empowering. I think we've got to make it empowering, and I think you've got to help us make it empowering. So that's what I'm going to talk about today. Today, I'm going to talk about four things, I think. I'm going to talk a little bit about institutions, because some people live in institutions. I'm going to talk a little bit about people living in the community. I'm going to talk a little bit about who should be doing the empowering work. And I'm going to talk a little bit about the Mental Capacity Act. So, if we start with a sociologist who spent, about 50 years ago, he spent a year working in an institution as a care worker. This was in America, and it was a large institution. It had some 7,000 people living in it at the time. And he published lots of essays and lots of books about it. And he basically said that institutions may be dangerous. They might be dangerous because they expect people to play certain roles. They expect the staff to play certain roles, and they expect patients to play certain roles. And that is a dangerous situation. I thought we'd have a quick think about what the word danger means, because danger doesn't necessarily mean the same thing as bad. It could be dangerous crossing a road, but it doesn't mean it's bad crossing the road. So we have to think about what the word dangerous means and how we protect against things that could be dangerous. And I think there's four ways of looking at danger in institutions. There's a danger of physical harm. For example, in Winterbourne, we saw things about physical harm. There's danger of neglect, about people not being cared properly. There's danger that people's identity is being damaged in some way, and danger that human rights are restricted. So prevention and empowerment is all about stopping these dangers from happening. I'm going to skip that. Let's look at communities for a moment. What prevents and what empowers people in communities? If people have good personalised care plans, that empowers people. If there's a choice about what support packages they have, that empowers people. If people are offered direct payments and they take them up, that's empowering. If people are helped to have strong voices in reviews, that's empowering. When people have a circle of support, that's empowering. And consulting people, choosing who should be consulted, whether it's family members or friends or advocates, that's empowering too. Lots of people should be doing empowerment. The government should be doing empowerment, and that's us, Department of Health and other government departments. The courts should be doing empowerment, and there should be lots of guidance on empowering as well. The regulators, the CQC, should be doing empowering, the College of Social Work, and commissioners. Commissioners have a very, very big role in empowering, in purchasing and commissioning and contracting in relation to empowerment. Managers and staff, that could be, for example, you. Managers building relationships and partnerships with service users, that should be empowering. And investing in these relationships through training, through helping, through scrutiny, all of this should be empowering. Social workers, I think it's an important role that you have, not just in protecting people, but also empowering people, in being client-led, in visiting clients, in empowering clients to ask, to complain, to report, and helping people, clients, to lead their own reviews. And you've also got a big role in whistleblowing, again, like in Winterbourne. So how does the Mental Capacity Act help us to do empowering? Lots of ways. It's got to focus on people who may lack capacity. So it's one of the few pieces of legislation which is almost entirely around people who may lack capacity to make decisions and who need help to make decisions. And the Act says we have to focus on people's wishes and we have to help them make their own decisions. The Act has some empowering principles, and the Act's got lots of champions and ambassadors, people who think it's a useful piece of legislation, people who want to use it. I want to talk about 9 ways of using the Mental Capacity Act, and as I've only got 10 minutes, I'm going to rush through them. One of the first things that the Act says is that professionals need to help people make decisions. So it's not make decisions for them or about them, but it's help people in all contexts to make their own decisions where possible. The other thing that the Mental Capacity Act says is that care plans should have wishes and feelings in them. So if you're working on a care plan or if your relative has a care plan, look to see where the person's wishes and feelings is there. Is it documented? Does it say this person likes this things, wants to do these things, likes to go horse riding, wants to do art, whatever it is that in the care plan? And are people being helped to have their wishes and feelings? Care plans should also be based on life stories. So people looking after other people should know a bit about the history of that person, should know what good experiences they've had, what poor experiences they've had, and should build on that. The Mental Capacity Act also says there should be an assumption of capacity. So no matter what form of learning disability somebody has, the assumption, the starting point should be that they have the capacity to make a lot of decisions. And that, of course, means that professionals have to offer choices so that people can make decisions about them. A fifth thing that the mental capacity says is that there is a right to make unwise decisions. We need to think about what that means, doesn't it? It often means risky decisions. And if we're social workers, care workers, it's difficult to allow other people to make unwise decisions and risky decisions. But the Act says that people are allowed to, and that we have to help them with that. Then the Act talks about best interests. It talks about making decisions and helping people to make their own decisions in a framework that's called best interests. So what is in somebody's best interests? Another thing the Act talks about is choosing things which are less restrictive of people's rights and freedoms. So it's about thinking what a person's right to family life is, if they're an institution, what their right to privacy is, their right to be involved in the community and in social activities. And all these have to be done in a way that's least restrictive of their rights. And then there's questions for people who are managers about how we plan a service around mental capacity issues at its heart. And then finally, I just want to say something about something that's called the deprivation of liberty safeguards. It's a horrible term, and people often focus on the word deprivation. They think it means taking something away. A deprivation of liberty safeguard, you have to focus on the word safeguards. It's a safeguard for people who are unable to do things and therefore need to be constrained and restricted and deprived in a care home or in a mental hospital or a different hospital setting. The safeguards are actually positive safeguards. So if somebody is offering you a deprivation of liberty safeguard in relation to a relative, it's actually very empowering for the person and very empowering for the family. It means a person gets an advocate. It means a person can take things to court for free, to the court of protection, and it safeguards the rights of the person through a whole series of assessments. So that's a positive way of thinking of a deprivation of liberty. So I'm going to stop there because I've been told 10 minutes only, but I'm very happy to answer questions at the end of the session. Thank you.
Okay, thanks, Paul, and good afternoon, everybody, or good lunchtime, I guess, to be accurate. So I'm going to briefly talk about a piece of research that the Mental Health Foundation undertook that looked at best interest decision-making under the Mental Capacity Act. And I'm going to particularly focus on the issues that arose from the research affecting people with learning disabilities, for obvious reasons, their families and staff working with them, and I hope to answer the question about whether or not it's an empowering piece of legislation, or certainly throw out some issues in the course of my presentation. So the research, just to give you a bit of background, research is a collaboration between ourselves, the Nora Fry Research Centre at the University of Bristol and the University of Bradford, and was funded by the Department of Health. The research is available on our website. You can download all the reports. You can download that for free. I've also brought a very small number of the summaries, which are there on the front desk, but you can also download that for free from our website as well. Just for those of you who are not familiar with us, we're a UK charity. We do social research, development work, provide information to the general public. We incorporate the foundation for people with learning disabilities. So we do work on, obviously, issues affecting people with learning disabilities, as well as people with mental health problems, dementia. So we can speak with some authority about how something like the Mental Capacity Act affects a range of people who maybe come under it. And we've done various bits of work, including campaigning for the Act, back in sort of 5 or 6 years ago, other research around the Act, and doing service development work to support its implementation as well. So the goals of the research was to find out really how best interest decisions are being made under the Act. I'm going to refer to it as the MCA, Mental Capacity Act. I hope that's okay, just otherwise it's a bit of a mouthful. And what are the kind of issues that come up when making decisions, making best interest decisions? That's decisions made on behalf of people who are unable to make a particular decision themselves in a range of different decision-making contexts. for it. And the three main areas we're looking at were health decisions, decisions around social care, and decisions around people's property and financial affairs. And the way we did the research was we had some focus groups at the beginning to sort of focus down on the particular questions that we wanted to ask. We then identified 4 geographical areas around the country. It was England only, so in England, where we wanted to carry out the research. And we then had various range of methodologies. The first one being asking people in those 4 geographical areas, mainly through NHS trusts and local authorities, but also the voluntary sector, the care home sector, to complete an online survey. And then from that online survey, good response rate, we had 392 people do the survey. We then conducted some telephone interviews and some face-to-face interviews to look in more detail about how best interest decisions have been made. And just one point about the online survey. We called it Bridget. My sister said, is that because I'm your sister? And I said, no, it's not. It's a complicated anagram of best interests and various other words. But we incentivise people to complete the survey because it generates, when you complete the survey, and it's still available, and it's a series of questions you work through around a best interest decision you're involved in. It generates free and confidential reports that's sent to you and to no one else, explaining how well the decision you're involved in adheres to the Mental Capacity Act. So there's it's a learning and development tool as well as a way of collecting data. So, in terms of respondents, the majority of people who responded to the survey and we subsequently interviewed were healthcare professionals. That's because in 4 geographical areas there's simply more people working within the healthcare sector than there were in the social care sector, particularly within statutory agencies. But that 20% represents about 77 social care professionals. And I should just say there were a number of people from the care home sector, from advocacy organisations and some family carers who responded as well. And the greatest number of decisions were about people with dementia, but you'll see that decisions involving people with learning disabilities were about 34% of the respondents, which by my calculation is about 130 decision-making situations involving best interests were reported on through the research involving people with learning disabilities. And yeah, I know those figures don't equal 100% when you add them up. That's because some people had more than one disability or impairment. In terms of the types of decisions, the majority of decisions, the greatest number of decisions were healthcare decisions. And for people with learning disabilities, that was also the greatest number of best interest decisions that were reported. But what we found in the research, that although the decision was, say, something to do with medical treatment, consent to treatment, for example, involving someone with a learning disability, actually, when we dug down a bit deeper and did the interviews, there are often other decisions involved, such as issues to do with social care, accommodation, and safeguarding. So sometimes there was a multiplicity of decisions that were that we were finding out. And usually healthcare decisions arose because of a change in someone's health condition or deterioration. Social care decisions tended to revolve around accommodation, safeguarding featured quite strongly. What we didn't find were many sort of everyday decisions involving people with learning disabilities or other impairments, which was interesting. It tended to be the big decisions, the significant decisions that the research was picking up. So 20% of the online survey said they were describing best interests that involved more than one of the above, healthcare and social care, which for those of you who know the Act, the MCA, that's not correct because you have to make a best interest decision around a specific issue, not a range of issues. So, strictly speaking, people weren't adhering to the law there. We think that might have been partly explained because people, for example, in a complex hospital discharge meeting may have been dealing with more than one decision, and that's why they reported that. But if people are making decisions, best interest decisions involving a range of issues for someone with a learning disability like that, that's clearly not empowering and it's not in line with the MCA. So there's a learning point there. So I'll try and summarise the key findings in my probably 5 minutes or whatever. So what the research found was that the MCA was widely welcomed by most people, most practitioners, most staff, most people who come across it and were using it. They found it a helpful piece of legislation. It clarified what had previously been a confusing area of the law. It was felt to give people rights, people who may lack capacity, to enhance their rights, as well as clarifying the roles and responsibilities of practitioners. And the research showed there was high levels of everyday practice which was adhering to the law and to the code of practice. And as you might expect, social care professionals particularly emphasise the importance of using the MCA to advocate on behalf of people's rights, protect people's rights. So I haven't got that broken down in terms of social care professionals working with people with learning disabilities, but that's encouraging to see that social care professionals were very conscious that this is a piece of legislation that should be used to empower people, to support people to make decisions. And apologies to any healthcare professionals in the room, but contrary to negative stereotypes that are sometimes held about healthcare professionals, they came out of the research well, because they were saying they often took into account personal and social factors when making best interest decisions, and they consulted with others when making decisions. So the concept of the doctor knows best wasn't reflected in this research, but it was a self-selecting sample, so one can never draw too many conclusions from that kind of point. However, there were some more greater areas of concern, and I'll go through them. Firstly, we asked some questions about how an assessment of capacity had taken place that led to a best interest decision. And what came up on a number of occasions was a lack of insight by the person who lacked capacity was equated with a lack of capacity. Now, lack of insight is not in the Mental Capacity Act or the Code of Practice as a way of as a test for lacking capacity. Lack of insight was described in the research as, they don't have no insight in their care needs or need for healthcare treatment. So that was a concern that something which is not in the legislation was being equated with what the legislation says. Certainly insight may be important if someone isn't clear about what their care needs are in determining capacity, but it shouldn't be conflated to mean a lack of capacity itself. People's capacity, and this particularly was concerning for people with learning disabilities, people's capacity was still being judged by their impairment. The point of the MCA partly was to get away from blanket judgments around this person has a learning disability, therefore they can't make decisions. But particularly people with more severe learning disabilities, the fact they had a severe learning disability was taken as an assumption they couldn't make a range of decisions on a range of issues. That's not in keeping with the Act. It's not in keeping with the decision-specific nature of the Act, and that was concerning. I think about 17% of the online cases, so that's 50-plus cases that were reported on, were where this general assumption of lack of capacity was reported. So that was a real concern. And it also relates, I think, to what was coming through, particularly for people with learning disabilities, that people weren't sure whether an unwise decision, perhaps someone making an unwise decision about their money, for example, or who they socialise with, or maybe that's because they lack capacity, and there was confusion about an unwise decision, which should still mean the person has capacity, meaning it's actually a lack of capacity the person has because of issues to do with risk and safeguarding, and I'll come back to that point in a minute. How long have I got, Paul?
A couple of minutes. Yeah.
Oh, a couple of minutes, okay. Faster. The other concerning thing was that in 36 cases reported in the survey, it was reported the person had capacity, even though a best interest decision was made on their behalf. So I hope most people in this room know that you don't make a best interest decision on behalf of someone unless they lack capacity. So why there were 36 people who are having a best interest decision made on their behalf, we don't know. The majority of those were in healthcare matters. I don't know how it breaks down in terms of learning disabilities, but there's a real learning point, perhaps to share with your colleagues. I'm sure no one in this room would make that mistake, but to share with your colleagues if there's that kind of things happening. I won't read through these quotes because I'm conscious of time, but there's a couple of quotes here. One sort of conflating this kind of all mild autism, challenging behaviour, etc., with, therefore we felt he lacked capacity. The second quote, I think, illustrates well about involving others, involving family carers, paid carers, understanding a person's different means of communication to try and ensure that they were able to make a decision or supported to make a decision wherever possible. We'd looked at the way best interest decisions were made, and often these were through meetings or a series of meetings. I won't go through this slide in detail, just to say that a series of meetings was the most common way, but that tended to be more for social care decisions rather than healthcare decisions. People with learning disabilities tended not to be so involved in best interest decisions meetings, which was concerning in some respects, but there was a lot of really good evidence reported about how they're involved in the decision outside the meeting, through involving circles of support, person-centred plans, using communication methods which enable them to make their views known without sitting down in a formal meeting. So that was encouraging to hear. And family carers in particular were often involved in a best interest decision meeting, certainly as reported, so that was good to see that that was taking place as well. But decision making was complicated in multidisciplinary settings, because what it says in the Act says, oh, the decision maker does the best interest decision, blah, 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 and actually in multidisciplinary settings it's much more complicated than that, particularly when you've got a range of complicated decisions to make. So here's an example of acknowledgement that by a practitioner that it's not a single person's decision. Multidisciplinary working is helpful. But also a quote there, if you have time to read it, that sometimes it could be a bit of a fudge, that no one actually really wanted to make a decision. People couldn't quite decide what to do, and that wasn't necessarily in the best interests of the individual. I've got about a minute to go, Paul, so if you bear with me. There were some real concerns about, the research raised some concerns about risk and safeguarding, sometimes overriding the Mental Capacity Act. And what I mean by tail wagging the dog was, this certainly affected some people with learning disabilities and people with dementia as well, is that there was an example, for example, of someone who was felt not to be managing their money very well, socialising with people who were taking their money off them, the person with learning disabilities, and it's a risk, it's a safeguarding issue. What can we do? How can we use the Mental Capacity Act to safeguard them? Or we can make a best interest decision on their behalf and do it that way, which might result in a good outcome, but isn't actually protecting the person's rights and going about it in the right way. The starting point should be, can this person make decisions about their money? And if they can't, then what's in their best interest, but not using the Mental Capacity Act to justify a safeguarding intervention unless it's absolutely clear that the Act justifies that. So that's what I mean by tail wagging the dog. There was some stuff about dolls as well, but I won't go into that. I'll just say something about family carers, because this was recognised to be important, particularly for people with learning disabilities. It often proved quite complex and challenging. There were examples of where family members were excluded from best interest decisions. Practitioners were reporting sometimes they felt they'd included family care as well. Family carers were saying that they felt very much excluded from best interest decision-making process. So I'm sure for many of you it's an ongoing challenge about how you balance the rights of an individual with learning disabilities, their decisions to live in a certain way, with what you feel is perhaps an appropriate sort of form of support or intervention. And in addition to that, you maybe have family members who are saying this is in their best interest, this is what's best for them. And as Paul says, I think it's particularly difficult for parents of people with learning disabilities who've been used to making decisions on behalf of their son or daughter. Age 16, suddenly it all changes and best interest and the MCA kicks in. So that was proving to be particularly complicated for people.
Can this be the last point? Because that's been a very long minute.
That's a very long minute. Okay, well, that's my last point, is just to say that, so what the research showed, there's some really good examples of the Act being used to empower and protect people, support and safeguard people with learning disabilities, but in some cases it wasn't always, wasn't such a positive message, and I think this point is a kind of a nice point to end on, because it sums up the kind of tricky balance that people working in learning disabilities had to make when using the Act, about balancing up a various range of issues to do with people's best interests, but always aware of the person's ability to change their mind and be involved in future decisions in the future. Thank you very much.
Okay. So I'm really going to pick up on the practical implications of the Mental Capacity Act, and probably will concentrate on assessment, as Toby has touched quite a bit on the best interests. Okay. When you might question capacity, first of all, the person has to have a mental disorder as defined by the MCA. Probably going to it may appear as I'm going to contradict what was said earlier, but if you're working with someone who does have a mental disorder as defined by the MCA, and they're making a series of several unwise decisions, it doesn't mean they lack capacity.
Steve, sorry, some people are indicating that they can't hear.
Okay,
I don't know whether we can turn the microphone up, or perhaps you could just speak a bit louder.
Yeah.
Thank you.
Is that better? Okay. So if you're working with someone that does have a mental disorder as defined by the MCA, and they are making a series of unwise decisions, doesn't mean they lack capacity, but I would say that some extra emphasis needs to be placed on the actual assessment and perhaps looking at the assessments previously. If you believe the person is being coerced, they're suggestible or more likely to acquiesce, then you might begin to question that individual's ability to make a particular decision. Some of the common scenarios which have already been mentioned, which you may be involved in to assess capacity. We've heard it should be decision specific, and someone may be able to make one decision but not be able to make another. It can be partial, temporary. I mean, I don't want to cast aspersions on any of you fine people here, but 12 o'clock tomorrow night you may lack capacity. 12 hours later on Saturday morning you may have regained it. So it changes, it fluctuates. So who assesses capacity? This will normally be the person who would implement the decision if it was going to go ahead and the person agreed. So in case of surgery, the surgeon, dental, dentist, etc. But it would be very good practice for that assessor to involve parents, family, support workers, health and social care professionals in that assessment, people that know the individual well and specifically the way the person communicates. Second principle of the Act, especially important for people with learning disabilities, we have a responsibility to enhance capacity, to show that to demonstrate that we've given enough information in a way that is accessible to that individual and their individual communication needs. At this point, we're actually giving the person information. If you're assessing capacity, this would be the same time where you would be setting the bar, the pass mark for your assessment. Because in order to give the person the information, they need to make the decision. You need to know what information they need to have. So you give an example of any medication out of the British National Formulary will come with a whole range of possible side effects. And it would be impossible for anyone to remember every single one. So that person who we're assessing their capacity, they need to be given information on A, the likelihood, the ones that are more likely to happen, or B, the ones that will have the greatest impact. So they wouldn't need to remember every single side effect of paracetamol. I'll give you an example. If any of us were going, or anybody with a learning disability at all was going for a general anaesthetic, you would be required to know under your capacity assessment that there's a 1 in 250,000 chance of dying through that procedure if you actually an average person. It may increase with certain other conditions. So you'd need to know that because of having the greatest impact. The status approach to capacity, which Toby mentioned. The other one would be the outcome approach, which you may have seen implemented in the past. Give you an example, I take my nephews out to McDonald's Saturday afternoon. I'll go to them, what would you like to drink? Each 4 of them will go Coke. I'll say, no, you can't have a Coke, you can have an orange or a milkshake. So you let the person make the decision, you don't agree with it, then you take it away and you make the decision. The functional test has 4 stages, and an individual needs to pass all 4 stages of this test. So they need to show that they've understood the information relating to that decision, they've remembered it long enough to make the decision. And this, through experience, the third one would be the one where sometimes people with learning disabilities may fail on if they are going to fail, would be to show that they've actually used and weighed the information as part of their decision-making process, and they need to be able to communicate their decision. So in terms of a couple of scenarios, in terms of medical treatment, the person just needs to understand in simple, plain English terms what the medical treatment is. They don't need to know the ins and outs and the medical jargon. They need to know why it's being proposed, what's its principal benefits, risks, and also the same for any alternatives as well. But they also need to understand what broad terms would the consequences of actually, saying no. Also, and if you're doing an actual assessment of capacity with someone with a learning disability, who may have a history of not being able to make their decisions in the past, people taking that privilege away from them, they may not know that they have the opportunity to say no. So that should be one of your key questions. Do you know that you can say no to this? Or if they agree into a medical procedure or another kind of decision, do you know that the person needs to know that they can pull out at any time? They can stop taking that medication. They don't have to do what's being proposed. They can change their mind. Some information you might need to give them. So you need to give them information and perhaps translate it into an accessible format. There's lots and lots of resources out there these days. easyhealth.org.uk is an excellent resource. So some of the questions you might start off with, just a very broad question, could you tell me what we were talking about earlier? And you may get all the information you need back from that one question. If not, you may need to start to asking some different probing questions. So what are good things about having this done? Will it make the cancer go away? Will it make me better? What are the bad things? They might tell you it might not work. I will feel very sick. So it's important about setting the bar. What do you want to hear back from the person to say they have capacity or they don't? And the bar for someone with a learning disability or dementia or anybody else defined under the MCA is exactly the same. It shouldn't be lowered or should not be higher for any particular group. What needs to happen is you might need to change the way that you're giving information to the person. You might need to change the questions you're asking them. But the information should be the same. And I would suggest to you, if you come across anybody that's lowering the bar, it's because they're imposing their own values on the individual. They want that person to have this treatment. They want them to say yes. If they're higher in the bar, the pass mark, it's likely that they don't want the person to have this treatment intervention and they're trying to stop them from having it. A big issue for social workers at the moment, care managers, capacity to engage in a tenancy agreement. So some of the information that might be given to individuals, you'll be living in this house with these people, you'll be paying rent, it means you have to pay this amount on this date of the month, you have to pay for food, electricity bills, etc. You need to take care of the house, that means you have to make sure you look after the things, etc. So if you don't pay the rent or pay the bills, you may be told you can't live there anymore. The person who owns the house, this is who you pay rent to, is the housing association. They have to do things for you because you're living there. They have to let you live here, make sure things work, etc. So it's about giving them the right information and then asking questions to actually test whether they've understood that information, they've remembered it, and they've used and weighed it in their decision-making process. So I said you'd be paying money called rent. Can you tell me how much you'd be paying? Can you tell me why you have to pay it? What else do you have to pay for? Bills, etc. What happens if you don't pay? This is probably my most important slide. I keep saying the words set the bar and pass mark, etc. But it really is a conversation. It's not an exam. It's about making the person feel as easy as possible and trying to enhance capacity, supporting people to, make their own decisions. There's no prescribed amount of knowledge as the person has to demonstrate. So it's a, balance of probability. It's a judgment made by the person that's assessing the individual's capacity. What they need to show is evidence if it's ever questioned, especially, that this is the information I gave the person, these are the questions I asked, this is where I set the bar, and these are the reasons I say yes, they have capacity, or the reasons why I say no, they lack it. A couple of last slides. Models of decision making. Obviously, if you have capacity, you can make your own decision. Anybody, if they have capacity, can make an advanced decision. You can only to refuse treatment, not to demand it. The approach used in the States, substituted judgment. What would I do if I was standing in that person's shoes? Some researchers suggest, though, they took a number of people who were likely to lose capacity in the future and who would they would choose as their substituted judgment maker. And answers only were the same in 75% of cases. 25% of people who were making decisions on behalf of other people was not the decision that the person would have made themselves. So the approach in this country, in England and Wales, is the best interest approach, which Toby mentioned. Now, I won't go through all of these cases. I'll choose one. These are lots of the cases that help develop the Mental Capacity Act have included people with learning disabilities. The first one I'll concentrate on is Y. Y is a young lady with learning disabilities, high support needs. She has close contact with her mum and her sister. Unfortunately, her sister has developed a rare form of leukemia and requires a bone marrow transplant. Just through previous investigations, they know that Y is a match. It's been assessed that Y lacks the capacity to make the decision whether she should donate her bone marrow. So some of the things that they considered when making this decision: if it went ahead, Y would continue to enjoy visits from her mum and sister. So they're looking at the relationships there. She has a good relationship with both her mum and sister. If sister becomes unwell, visits from mum would reduce. So it's going to affect her social welfare. Strong possibility sister would die without the transplant, and we know that she has a good relationship with her sister, so that relationship would end. Sister was more likely to recover with Y's bone marrow. Though it's her sister's best interest is not the issue, sister's survival is in Y's best interests. So I suppose the point there is you never consider how a best interest decision will impact on somebody else unless it impacts directly back on the person themselves, because it's only about what's in the best interests of that individual, and in this case, Y. The operation would be traumatic and uncomfortable. But we do know that Y has been through 2 general anaesthetics before, and she has no greater risk than the rest of the population. Family could support her through the procedure. She could have painkillers following the operation, and they said yes, that her bone marrow could be harvested.
Could you just make some concluding comments?
Yeah, sure. Yeah, just to say that the Mental Capacity Act, when making best interest, say you should use a balance sheet approach. And should look at it from 3 different perspectives: the medical perspective, social welfare and emotional perspective. And you should look at the possible disadvantages and advantages from both, and then make a decision based on which outbalances the other. Thank you.